And in other Supreme Court news, the justices ruled unanimously in favor of an evangelical Christian postal worker who argued the U.S. Postal Service didn't do enough to accommodate his request to not work on Sundays. The decision is a major victory to religious groups, greatly expanding how far employers must go to oblige the religious views of their employees. Back with me is MSNBC legal analyst Lisa Rubin. So explain this, Lisa.
Katie, this decision, as you just mentioned, was brought by an evangelical post office worker who wanted to rest and worship on Sundays and whose post office wouldn't accommodate him because of all the Amazon packages that they have to deliver. He sued under Title VII, that's federal employment discrimination law, and he said that his employer, the post office, didn't do enough to accommodate him. The Supreme Court used it as an opportunity to clarify precedent that they have that's several decades old. And lower courts used to interpret that as saying anything more than like a de minimis adjustment or accommodation was an undue hardship for an employer. Now, that's no longer the case. Now, the employer has to accommodate the employee unless that would impose substantial costs on the business itself. So it is a major shift with all 9 justices going along for it, as you just noted.
It's unusual to get all 9 justices to vote unanimously, right? Rule unanimously.
It is. And, you know, the whole nature of most Supreme Court cases is such that there is some divisive issue or lower court split that necessitates resolution, and that usually doesn't lend itself toward unanimity. But here, one of the things that the justices were struck by was how many religious groups were in favor of clarifying this test and who basically came before the court as amicus to say religious employees in this country who ask for accommodations more often than not are not getting it because lower courts believe that employers only have to change their practices or accommodate when the costs to them are low. And the court took that as an opportunity to say, no, that's not what the statute says. You, the business, have to change unless the costs of complying and accommodating the employee are so great to you that it constitutes an undue hardship.